Steberg is going to go first. She's with the Steberg Law Firm. Please save all of your questions until the end. Please know we're going to start questions at the end. You can go ahead and use the chat box or the Q&A, and you can put those in there. And then again, towards the end of the presentation, after Anita and Althea, we'll get to those questions. So without further ado, Anita, welcome.
Well, thank you so much, Jody. I am going to have a little bit of a slide presentation. So I'm going to start that. And there we go. Move this up. Just take me I'm not very techy, so I apologize for that.
No worries.
So
there we go.
All right, perfect. So I'm going to be talking about the basics of wills and trusts and other fiduciary instruments, as well as where I see as a litigator, you get into problems as a real estate professional. There we go. And so my name's Anita Steberg. I am the CEO and founder of the Steberg Law Firm in San Jose, California, where we help people with tax. We also help people with probate, trust administration, and litigation. The basics of a will, a trust, power of attorney, or conservatorships. These are the 4 documents where if you're going to be selling a house that people say, oh, I am the executor of mom's will. I am the trustee of mom's trust. I have a power of attorney. I'm mom's conservator. These are the language, if you will, of a fiduciary responsibility. Just for estate planning purposes, generally for estate planning purposes, there are 4 documents. There's a trust, a pour over will, a medical health directive, or sometimes it's called as a medical power of attorney, and a financial power of attorney. But when we talk about fiduciaries and what gives somebody the authority to sell a house or to make the decisions, we're generally talking about a trust, a will, a power of attorney, or a conservator. And they're a little bit different. So I thought it'd be really good to start this off with saying kind of what the differences are. For a trust, that is effective during the person's lifetime. It also becomes irrevocable generally after somebody passes away. A trust only controls the assets that are assigned or titled to the trust. And for real property, you're looking for that real property to be titled in the trust. And that is done by recording a grant deed or a trust deed where it's going to say, Anita Steberg hereby grants to Anita Steberg as trustee of the Steberg Family Trust. That tells me it is the trustee that can sell the home. A will only becomes effective, 1, upon the death of the person, and 2, upon a court order. Unless the court has appointed that person as executor, it does not matter what the will says. They do not have the power to act. It only is effective when the court appoints the executor. And it only controls assets that are outside of the trust, outside of a joint tenancy, outside of a designated beneficiary account like a life insurance, and outside of payable on death accounts. You know that you are dealing with the executor if they can give you certified copies of the letters that are issued by the court, and those should be recorded for title purposes. A power of attorney is this is effective while the person is living. It states who can make decisions if there's an if the person becomes incapacitated. Generally, we're talking about either a medical power of attorney, sometimes it's called a medical healthcare directive, or a financial power of attorney. These are only effective during the person's lifetime. The minute that person passes away, these are no longer effective. So if mom has passed away and the real estate agent is told, hey, I'm mom's power of attorney, I want to sell her house, they do not have the authority under the power of attorney. Generally, the power of attorney is recorded. And then we have a conservatorship. A conservatorship is a court process where the court appoints a specific person. It could be a professional fiduciary, it could be a family member, it could be a friend. The court appoints a specific person to take care of that person's financial matters or their healthcare and their personal decisions. These are only effective once the powers are granted by a court, and then you generally, once again, those the letters that the court issues are recorded. There are two types of a trust, and I'm going to talk about revocable living trust. There are a lot of other types of trusts, but I'm talking about your your living trust or your revocable living trust. During your lifetime, it is generally revocable, amendable. It's a disregarded entity. You can do whatever you want with those assets. Once that person passes away, it becomes an irrevocable trust. And if for a real estate transaction, you want to make sure that all the documents and the contracts mirror how the property is currently titled, if it is under a trust. So if I am selling my house and my house is titled as Anita Steberg, trustee of the Steberg Living Trust, the documents that you give me to sign should say Anita Steberg, trustee. You always want to make sure the contract is mirror how the property is titled to make sure that the person is acting in their fiduciary capacity, not their personal capacity. And that becomes important because if they are acting in a fiduciary capacity and they sign as a personal capacity, that document might not be enforceable. With the will, we talked about that very briefly, but when someone says, well, I need to probate a will. Well, what does that mean? Or I'm in probate. What does that mean? So under the general terms, what it means to say probate is there's a court process to appoint an administrator or executor of the person's estate. Once again, we're not talking about a trust. This is with the will, and to settle the probate estate. Additionally, it can mean a couple of different things as well. Generally, when we say, what does probate mean? Or, hey, I'm probating my mom's estate, generally we're referring to a will. But the probate courts in California have a much wider jurisdiction. All trust, estate, conservatorship, elder abuse, power of attorney issues, and a lot more, all come under the probate court jurisdiction. And with any type of court filing, remember those are public documents. Anybody can go in and look at those documents, not that they will, but they could. The same way that you can go to the county assessor's office or the county recorder's office and you can see who owns the title to what property. So generally, when someone says, hey, I'm probating my mother's estate, or I have to go probate, generally referring to a will, but does not necessarily have to be a will, because the probate court does have broader jurisdiction. You want to, if you're dealing with the client who says, I'm in probate court, or I'm seeing a probate judge, you want to make sure that you understand the procedure they are going under. A trust that has been brought under a court supervision is a very different process than a conservatorship. And it's a very different process than an elder abuse litigation case. And it's very different than a probate estate. Every process kind of has its own lifeline and its own process. So you want to see kind of what's going on and ask those probing questions. It's very important when you are dealing with a person in a fiduciary capacity, maybe mom has dementia, or maybe mom has passed away, that the signature lines of the contracts that you as a real estate professional are having them sign designate their fiduciary capacity. So if we go with Joe Smith, if Joe Smith is acting as the trustee of mom's trust, it's going to say Joe Smith trustee. There are several different variations on trustee as far as abbreviations. It does not have to spell out trustee. I've seen it TT, I've seen it TEE, just something that's designating Joe is not acting in his personal capacity, meaning it's not Joe's house. His only right to sell it is because he is in a fiduciary capacity. If somebody is administrator or executor of the estate, you want to put that designation behind that. Once again, if they are a conservator for mother's estate or dad's estate or somebody else's, you want to put Joe Smith conservator. And once again, those lines are from a contract standpoint, those become very important when you sell real property. when should an estate plan be done? We get that question a lot. And there are some people that say, oh, it's only worth it if you have real property. I disagree with that. Anybody over the age of majority should have an estate plan, no matter the amount of assets. And the reason I believe that is because if you don't have anything, the state of California, if you die at 25, will determine where your things go. If you, every state has a estate plan, whether you want it or not, and under California, it's under the California Probate Code, and it follows basically bloodlines. We call it heirs at law. And so if you were to pass away and you're single, it first goes to, and you don't have any spouse, first it goes to your surviving spouse, then it goes to your kids, then it goes to your parents, and it goes on and on and on. But what happens if you're 25? You have a falling out with your parents. Your girlfriend knows you the best, and you've lived with your girlfriend for the last 5 years. And this is a long-term relationship as far as you're concerned. Under California laws, unless you have a document giving your girlfriend the authority to act on your behalf, whether it's that's who inherits your stuff after you're gone, that's who makes your medical decisions. If you're in a car accident, it's going to be your heirs of succession. It's going to be either your parents, it can be your siblings, whoever is in the line of succession under the California Probate Code. But if you have a document that says my girlfriend can make these decisions and my girlfriend is the one that inherits all my stuff, no matter how much or how little it is, then it goes to where you want it to go. So I think an estate plan should be done at any time for everybody once they reach the age of majority. My daughter has a terminal liver disease, and we've had her estate plan done since she was 22. We changed it several times, but because we knew there was a need, and at some point she might not be able to make the decisions, and she wanted her boyfriend to make the decisions. Now they're married, now it's her husband. So it is very important that those documents be updated, and it's very important that you are choosing who's making your decisions and that you are comfortable with that person making the decisions. Now, you might not need the full estate plan. Maybe all you need is a will. Maybe you just need a will and the durable power of attorney for financial decisions and the medical directive, which is the power of attorney for medical decisions. Maybe you would need a trust too, but that's something an estate planner can help you decide. When we talk about our elderly population, there are some issues that are very significant with them. Especially when somebody has dementia. And I'm going to talk about dementia in one fulfilling umbrella. It doesn't matter to me if it is Parkinson's disease, perhaps, if it is AIDS dementia, if it is diagnosis of dementia. There are a lot of different things. Vascular dementia, it doesn't really matter what it is. I'm going to use dementia in a very broad sense, which means diminished capacity, which means they cannot make the decisions for themselves. They've lost that ability. They've lost that rationality. And some of the issues with dementia is we know from studies in our population that just having dementia puts that elderly person at a higher risk for elder abuse. At one time, years and years and years ago, it used to be the financial advisor that may be the abuser. It would be the 20-year-old new boyfriend for a 60-year-old or 70-year-old person. However, as we've had a higher population of elderly individuals, it's normally family members. That has been proven time and time again. It's normally a family member, and generally it's the one that is doing the caregiving. They isolate the senior. They may manipulate the senior into creating a new will or a new trust, disinheriting everybody. But it puts that senior at a higher level. And when I say abuse, financial abuse is one of them. Sexual abuse is another. Physical abuse, emotional abuse. The elder is at a much higher level for abuse, as much higher risk of abuse, and whether that's physical mental, emotional, financial abuse. One of the issues that we come with dementia, and this is where you really need a medical professional, is does this person have the capacity, and we're talking about real estates, to enter into contracts? Do they have the capacity to sign? And what I mean by that is sometimes I'm dealing with a client and the client says, oh, well, my mom knows me. So, she has the capacity to sign things. Well, that's not what, under California law, what the capacity test is. And even as an attorney who does elder abuse litigation, I am always looking for the medical professionals, because that is in their wheelhouse to determine, does this person have the capacity to sign this contract that we need signed, whether it could be to create a will or a trust, or amend a will or a trust, or to prosecute the elder abuse claim. If you are dealing with the fiduciary, look at the documents. If they say, hey, mom, or hey, real estate agent, I am mom's trustee. I take care of her. I want to sell her house. Are you dealing with the appropriate person? You want to see that document. And one of the reasons why is if you're not dealing with the right person, you're wasting your time. Additionally, not only are you wasting your time, but you're going to have a problem when you go to sell that house, because title will ask. They're going to pull the last recorded grant deed. And if there's an issue with the chain of title, it says that Barbara is the trustee, but John is your client. And, you submit everything to title, you're ready to go. You're thinking you're going to close in a week. And you get a call from the title officer that says, wait a minute, this is not the appropriate person. And if you say, well, my client absolutely is the trustee, they're going to want to see the documents. So you are going to want to see the documents, not just take somebody's word for it. If they've already passed, if the person has passed away, for example, mom has passed away, once again, the power of attorney is not effective. The will is not effective until the court enters an order and appoints that person. And then we also have a ancillary issue with the transfer on death deeds. And I'm going to put a little star, a little asterisk on a transfer on death deed. Title companies do not like that. That is when you have a deed that says, upon my death, this property goes to X person. They are ripe for elder abuse. I've only known two cases that I've dealt with where the title company has not made an exception. One of them, it was just because the person who was the beneficiary under the transfer on death deed was the sole heir at law. So they allowed that to go without an exception. The other one, we had to get everybody who may have a right to that house under any document to sign off on it. Every other time I've seen a transfer on death deed, the title officer, the legal department says, no, we're not going to insure title. So there's a lot of issues with transfer on death deeds. If you come across one of those, talk to your title officer early. A duty to disclose, and I don't want to beat on this too much, but if you are dealing with the trustee, you need to use the trustee advisory form. If the fiduciary completes for a sell, and I'm specifically talking for a sell of a house, if the fiduciary completes the disclosure, they're going to have the same standard as the homeowner. They have a duty to disclose if the fiduciary is aware of any material defects that will affect the value or desirability, whether they've lived there or not. So you just want to talk to the client, make sure the disclosures are proper. If they don't know, that's fine. That's what you don't have to disclose. But even if they have not lived there, if they know the roof leaks, maybe, like I said, even if they don't live there, they have to disclose that. When you are dealing with somebody in a fiduciary capacity, these are some of the potential issues. Is a notice of proposed action required? Generally, if there's a trust and it is an irrevocable trust, you have to give a notice of proposed action to the beneficiaries. If you're in a probate estate, you have to give a notice of proposed action regarding the terms of the sale and how much the estate is going to get. If you have a conservatorship, You actually have to go in and get court approval prior to the sale closing. If you do a notice of proposed action and there is an objection, then you have to get in front of the judge for the judge to overrule the objection. So that leads us on to the next point, is court approval necessary for this matter. If you don't know, if you're a real estate agent, you can ask your manager. The person who's going to know is court approval is necessary is somebody who does elder law, an attorney, and when I'm talking about attorney, so an elder law attorney could help your client, attorney who does trust and estate administration or litigation can tell you when court approval is necessary. If court approval is necessary and you do not get it, that escrow or title is going to flag that issue and they are not going to allow it to close. Additionally, ensure all the contracts are executed in the fiduciary capacity, that they match the last recorded thing on title, whether that's letters of probate, whether that is a grant deed. You want to make sure it's consistent. And just a little thing about escrow agent instructions. You're going to direct funds go into the fiduciary account. And agents, you should not be advising regarding disbursements. And one of the reasons why is if you get that wrong, you may have liability. So I always tell my real estate agents, you should not be giving out that type of advice. When should disbursements be done? How should they be done? Where should they be done? Is everything wrapped up? Because you're just dealing with the real estate. There may be some other issues that you are unaware of. So we're going to answer questions let's see. And so we're going to answer questions. I'm going to go after Althea is when we're going to answer questions. And I'm going to turn it over to Althea, and I'm very excited to what she's going to be talking about.
I need a quick question. There's been a request for a copy of the slides. So I'm just wondering if that is something we can also have.
Absolutely. Jody, do you want me to send those to you after this?
Yes, please. And then we'll get contact info and all of that at the end. Thank you. All right, Althea.
Okay. And let's see, let me go and do the screen share to my presentation and go ahead and share. So let me just hold on a second. I'm having a little issue here with the different windows. Okay, so I'm Althea Kippis, and I'm, let's see, going to start the slideshow now. I am an attorney, a gerontologist, a real estate broker, and a professor. So I am very well versed in the different types of senior living communities, as well as estate planning and issues affecting older adults, which is what gerontology is. So let me go ahead and so we'll talk about first the types of housing for older adults. And I know everybody uses the term seniors and senior housing, but then when you start getting those junk mail AARP things in the mail that say you're a senior, you yourself will say, I'm not a senior. And so most people don't really like that term. They prefer older adults. So I'm just going to tell you that so you can make sure to keep that in mind. But because most of the world uses senior housing to talk about this, this is what we'll be talking about. So as a real estate agent or broker, you probably didn't learn about this in your SRES course if you took it, the Seniors Real Estate Specialist course. But basically, this will be a crash course in the different types of housing. And I'm going to tell you how you can be of value to your older adult clients and even help your own family members. So one of the first things is a continuing care retirement community. And so this provides all level of care. So you move in and you are completely independent. And the reason you move in is because maybe later on down the line, you think you might have health issues or something, the care is there when you need it. How much that costs, if there's an additional fee, that's determined by the contract. But basically, when you move into a community like that, they promise to care for you for all your care needs. And then certain contracts say, as long as you have money. So that's one thing to keep in mind. Some contracts, which we don't really see anymore, guarantee a life care. So even if you run out of money, they will still take care of you. Some examples of these communities I will share with you later, but let's just focus on the definitions first. So the next type of housing for older adults is what's called in California, the Residential Care Facility for the Elderly. So these are known as RCFEs. So sometimes you see them talked about as assisted living or board and care, or sometimes people will buy homes and you are representing them in the purchase and they say, I want to open a care home. So this is probably the kind of thing that they would be opening, because you can have 6 beds, 8 beds, and you can, have people living in a single family home, 2 to a room. You can take care of 8 people, you have staff, and you can charge them a lot of money, and the people are in their little home community. So these provide very good options for people who need help with basic things that they need to do every day, bathing, grooming, that kind of thing. A skilled nursing facility, these are abbreviated as SNF. People call them SNFs. I know one of the longtime elder law advocates says they call them SNFs because in the old days they used to smell really bad. So you sniff and it's like, oh, I'm in a nursing home. So things have changed. The state regulates these homes and these places provide medical care. So where I grew up after 9 years old was right at the intersection of Los Gatos Boulevard, Samaritan Drive, and National Avenue, right in San Jose, near Good Samaritan Hospital. And there must have been probably 6 to 10 board and care, skilled nursing facilities, assisted living communities, just right in that neighborhood. And as a child, I would go visit them and visit the older people living in there. And actually, that is what started my love for working with older adults. But anyway, these are medical facilities. You will see people go there after knee surgery rehab, things like that. The other type of housing is what we call independent living. This is like over 55 housing. So the only restriction is that you have to meet the age requirements. Some are over 55, some are over 62, some are over 65, but these are the different restrictions. There are usually no other services for that. So let me go ahead and talk about the different housing options. So the over 55 housing, independent living, is probably what most of you are familiar with. So if you are in the San Jose area, the Villages in San Jose is a prime example of this kind of community. So costs, the Bay Area could be 400,000 to over 2 million or more. There are different types of independent living housing for older adults. I use the Villages as an example because everybody knows where that is if you were in the San Jose area, Santa Clara County, but there could be certain condominium complexes that are designated to be for people over the age of 55. So in these communities, there is no care whatsoever. So you move in because you met the age requirement. Nobody cares about your health or how long you're going to live or anything like that. You just have the money, you can get a mortgage, you can buy property and live there. Sometimes services are included through the community's homeowners association. So there might be swimming pools or fitness centers, wood shops, craft rooms. The Villages, is the golf and pools that they're known for. They have stables there, which is, if you happen to go and know someone there or look at the properties, it's truly an amazing place to be. Staffing is usually just for running whatever their homeowners association requires. So maybe at the Villages in San Jose, I know they have a bistro, so they have people working in the bistro, they have people in the office, but there's no one there that provides medical support or support to keep you living in your home. So what you should know about that are the residential real estate contract forms, which you probably already know since you belong to SCORE. So there isn't usually anything additional other than reviewing the HOA documents. The red flags are, really the thing I see the most with people moving into over 55 communities is the failure to have any kind of estate plan in place or any power of attorney or anything. And what we see when people move from there is all kinds of problems, because if people die without a will or without anything, their property ends up going to someone who they probably didn't want their property to go to. So there was a case I worked on where that was the case. The person had a significant other, but there was no will, there were no documents whatsoever. The significant other has no rights, they're not married, and the property went to this niece who the person hadn't seen in 30 years and who didn't in life shared that he didn't really like this person very much. So I doubt that that's how he wanted his property distributed. So that's the warning. The red flag is if you're moving into an over 55 community, you should start thinking about getting your estate planning documents in order. Who's going to get your property after you die? You should take care of that. So let me go to the next slide. Here are some examples. These are from the villages. There's also a really big villages in Florida, but these are pictures from the villages in San Jose, and they have RV storage and stables. It's really a great place to be. So check it out. Okay, so continuing care retirement communities. So these are things that are really beneficial, but there are a couple of things you have to be wary about. So some of these communities can be a real estate purchase or they are a buy-in. So a buy-in is basically the right to live in the community. So you may pay what the equivalent cost would be of a single family home, but you're not owning any real estate. So for example, let's say one of the continuing care retirement communities that people have heard of is the V on Stanford's campus. So you could pay $2 million and they'll show you this really lovely unit that's just absolutely beautiful, but you don't have the right to live in that particular unit. You just have the right to live in that community. And if your level of care changes, where you are living is going to change. So they will move you, okay, you moved in, you were perfectly fine, then maybe you had a stroke or you had a fall or a terminal, some kind of long-term illness. You can't take care of yourself anymore. They are going to move you into another location where it's convenient for them to take care of you. So that's what a lot of people don't understand. It is a little harder to do that if you actually own the real estate. So there are certain communities where you can do a real estate purchase. Rancho San Antonio, the Forum, is one of those places. The Stratford in San Mateo is another place. Those are real estate purchases where you fill out the same car forms to buy the condo, but it's real estate purchase plus the continuing care contract. And I'll talk about that in a second. But the cost for buying in or purchasing something, I have seen as low as $150,000 up to over $3 million. And the thing you want to know is it's cash only. You cannot get a mortgage to move into any of these communities. So these are ideal for people who maybe have all the people who bought real estate a long time ago and now their property is worth a lot of money. They can sell that property and move into one of these communities. But that comes as a surprise to many real estate agents because there are no mortgages, it's cash only. So if you look on the MLS and you will see listings for, I think, Stratford, which is in San Mateo at 601 Laurel, then there's a couple of other places and they say cash only. This is why. So a lot of times if you look at homeowners associations and the private remarks say cash only, it's because it's in litigation. It's not the case with continuing care retirement communities. They are not, you cannot finance that purchase. Again, all level of care are provided. So you can go from independent living all the way to medical treatment in a skilled nursing facility. And this is why the contract is so important. Your contract controls how much you pay for those services, if you pay anything extra, and how they're charged and how your care level is determined. But usually these places are very nice. They do everything for you: meals, transportation, housekeeping, laundry, cooking, activities, all kinds of fun things. Staffing is, you know, they'll have employees to drive you, to prepare your meals, to do activities. But again, the contract is critical. And I will tell you, most real estate agents, if you're a good agent, you will advise your client to have an attorney review the contract, but you need to have an attorney experienced in continuing care retirement community contracts, care agreements, review the contract, because you can't change any of the terms of the contract. The only thing an attorney can do is help you understand what the terms are. So when I, in my role as director of sales and marketing of one of these communities, would see where the people would hire, and they would hire the wrong kind of lawyer too. They would hire a real estate lawyer, which is, you need an estate planning lawyer. You're at least in the right direction when you go there. But these lawyers would charge them $5,000, $6,000, and they would mark up this 300-page contract in extensive detail. And it's like, well, thank you, that's interesting, but you can't change any of these terms. The state approves them, and this is the contract that's used. There were other ways and little things you can get, but it's not going to be anything affecting the major terms of the contract. Some provisions to watch out for in these kinds of contracts could be things that determine who sells the real estate when the person passes away. Some contract provisions restrict the sale of the property to the employees of the company managing the CCRC. So that means you as the real estate agent will not be able to sell that property, because they say the only people who can sell these condos are our employees, or that may be limited for a certain period of time, or they may have no restriction. The other thing is looking at the monthly care fees and when do they stop. Some contracts say they stop, you know, as soon as you move all your stuff out of the unit and we can sell it. Some say within 30 days after the person can't live there anymore or dies. Some say until the unit sells. So some contract provisions will continue charging you the monthly fees, even though no one is living in the unit. And you have no control over that because they are in charge of selling the unit. So there's really not a lot of incentive to really step up on selling the unit because they get their money either way. So this is why you need to review the provisions of the contract. Well, I say you in general, the family, your clients, you need to hire an attorney to explain those provisions so you know what you're getting into. Other things to watch out for, sometimes there were errors in how things are calculated. So always check the math in the contracts. How is the level of care determined? Who decides when someone needs to move from an independent living to an assisted living unit, and how is that decided? What happens if the place goes out of business? There's provisions in there for that. So there's a lot of different things to look out for that, you know, this is why they hire an attorney to review the contract. And okay, a little plug for me. This is one of my very narrow areas of expertise. And so if anyone has questions on these contracts, you can reach out to me and I can help you or find a resource for you. Then here's some examples. So I've got the V in Palo Alto. Many of you may remember the Oddfellows home in Saratoga. So now it is Saratoga Retirement Community, but the 3 links still show the connection to the Oddfellows. This is Rancho San Antonio down here. And then I put a picture of the Stratford. So you can see that the kinds of units are houses, cottages, typical things that look more like condominiums, what you mostly will see. Let's see. So the next one is residential care facility for the elderly. So with an RCFE, you don't have, did I just go back to this slide? Let me see. Go to the next one. Yes, sorry. We covered RCFE already. This is the skilled nursing facility. So again, you don't have the real estate interest, but costs can range from $12,500 to over $16,000 per month. This is crazy. This is why, you know, we are going to be facing a huge crisis in our community about who is going to care for older adults. The thing is about skilled nursing facilities is people are in there because they have some kind of medical care that's required. So maybe they have a feeding tube, or maybe they have a catheter or something like that where they need nursing care. In a skilled nursing facility, there are meals, transportation, medical appointments. That is typically included, but they will bill you for extra services. Staffing is typically by they will have licensed vocational nurses supervising, usually on each shift, and then they will have certified nurse assistants. And so the staff is trained medically. Again, you will probably have a contract, but it's typically month to month. And then the provisions to watch out for are what happens if the person passes away. How long are you obligated under the contract? What happens with different levels of care? And the other thing that's very important is these estate planning documents that Anita was talking about are very important, because you need to have those to really prevent problems later on. And I think I'm going to go back to the previous slide after we finish this. So here are some examples in the Bay Area. So one is, this is Plumtree Convalescent Hospital, which is Plumtree Care Center. Here's one, Vizona Creek Healthcare Center. So skilled nursing facilities will typically call themselves health centers because, you know, the bad negative connotation with skilled nursing facility or nursing home. Nobody wants to be in a nursing home, but it's much nicer to be in a health center. So if this level of care is also included in the continuing care retirement community, and typically it will be called a health center. They don't call it a skilled nursing facility because that, from a marketing standpoint, isn't very good. And I believe, I just wanted to check here because I'm just going to, let me escape out of this. It's driving me nuts. We talked about the skilled nursing facility here, and I wanted to make sure to call attention to the residential care facilities for the elderly and the board and care. So I wanted to make sure you understood the difference. So in a residential care facility for the elderly, you will have services provided to the person living there, which are assisted living services. So they help someone with bathing or dressing or eating. They cannot take care of medical problems. So if someone cannot inject themselves with their insulin anymore, they need to be in a medical facility where someone is legally authorized to do that. Again, cost for these residential care facilities, you know, you're looking at $6,500 per month to $12,000 or more. A lot of the large chains of these residential care facilities will say assisted living, but many of them are for people who need assisted living because they've developed dementia or they have mild cognitive impairment, which is what MCI is. So this is kind of where the difference, if somebody has dementia but doesn't have any medical needs right now, you can live in a residential care facility for the elderly. A lot of people and real estate agents don't understand the differences, but when you go look at residential care facilities, it's because people cannot take care of their what are called ADLs, activities of daily living. And it's because the most common reason is because they have some kind of memory loss or dementia developing. Again, there are contracts here, but typically these are rental communities. It's a month-to-month contract. What to watch out for is how are the people trained? What kind of training? I will also let you know that these types of facilities are often owned by investors. So many of the large chains you see, their locations are owned by investors. So when you have a for-profit operation owned by investors, the investors want to get as much money as possible. And they are going to do things to increase their revenue. So some of that is not paying the staff a living wage, not providing insurance or providing really crappy insurance, or not charging for everything. They will charge you for everything extra. And also they're not that great for the employees. So you really have to look at the different places. And this is a situation where the large chains are not always the better ones. So anyway, I'm talked enough about that. Questions to ask before moving in. These are some of the questions. fee increases? What are the monthly fees? Who is the one that's going to be selling the real estate ownership in the continuing care retirement community? And then also additional costs and what those fees are. Some questions you should always ask, what is, how long do employees stay there? And they may tell you something, but you can go on Indeed or Glassdoor and look up the reviews from the employees on that company. And pretty much you'll see a lot of disgruntled people posting, but some of the stuff is accurate. And I always tell people to check that out. And then the other major thing, which is topic for another time, are mandatory arbitration clauses. And, this is something you do not have to sign. And there are a number of resources. And I would tell you before signing a contract, look at this because you do not have to sign in order to get the services. Anyway, I want to tie it back to the estate planning documents that these places will require your trust or will. Power of attorney for financial services, medical directive, and there's another form called a post, which is completely optional. You fill it out with your doctor. So anyway, thank you. Sorry, I went over a little bit on my time, and I will stop screen sharing now.
Thank you both. I think there's, as you guys can see, there's a lot of questions in the chat box with a lot of really good information. So I'm just going to start at the top if that's okay. Anita, it looks like most of these will be for you, and then Althea, as we go down, we'll see more. So I'm just going to jump into questions. If you do have questions, put them in the Q&A box, and we'll get as many as we can answered in the next 10-15 minutes. So the first one is with the girlfriend-boyfriend situation. If the girlfriend's living with the boyfriend for at least 6 years, which I'm assuming they're talking about common law type things, does the girlfriend get all of his stuff?
Maybe in other states. In California, this is a largely misconception. It's like, oh, we've lived together for X amount of years, so we're in a common law marriage. You refer to each other as husband and wife. You'll introduce each other as husband and wife. Legally in California, we do not recognize common law marriage. So you could be with your living partner for 20 years. That partner passes away. You have no legal rights unless you have a document that gives you those legal rights. So if they don't have an estate plan, you as a longtime girlfriend will have no rights to that person's stuff, to that person's property. So it becomes, when people say, oh yeah, but we've been living together for so long, California does not recognize common law marriage. You either have to be married to have a marriage, or you need to be registered as domestic partners. Either two of those will suffice, but just living together and referring to each other as husband and wife does not give you any rights under the law. Other states are different, but California, we don't recognize it.
Okay. Are certificates of death public information on a county website? I'm going to assume,
I can see that being asked one of two ways. Are death certificates available on access to the public? No, they're not. Or if you're talking about an affidavit death of trustee, something along those lines, those are recorded with the recorder's office in the county. And yes, you can go into the county's recorder's office and you can see an affidavit death of trustee if that's what you're talking about.
Okay. What is the title of the right attorney that can review the CCRC? Like what kind of an attorney, I assume that is?
The continuing care contract for a CCRC would be an estate planning attorney, or honestly me. I don't know anyone else who reviews these contracts or understands them like I do. So if that's something you want to do, I'm sorry, this sounds like a shameless promotion of me, but I don't know anyone else who does it. This was a very narrow area of expertise I developed over many years. And so as far as I know, I'm the only one. But if you do need to look for attorneys who do that, look for estate planning attorneys or elder law attorneys.
And I'm going to give Althea props. I do elder what's considered elder law. I do trust and estate administration litigation, do contested conservatorships. I know that there are not a lot of attorneys that review those documents. I do not review them. I say, nope, this is outside of my scope of expertise. So it's really important that you contact Althea or somebody with that exact skill set, because they're very complicated. If you've ever seen those documents, I don't think she's exaggerating when it's 300 pages.
And just from personal experience, you don't realize how much of those extra costs are a la carte, like she was talking about add-on care. You may send, a person to live in one of these places and it just seems straightforward, they're going to live. Well, then they need that diabetes shot, or they develop dementia, or now they can't cook for themselves. And all of a sudden, those costs will add up extremely quickly. And you didn't realize it because it was all outlined in that contract, somewhere in the 300 pages. So, let's see. My client went to get a power of attorney from mailboxes, etc. Is this legit? I feel like maybe, no.
Althea, I'm gonna answer that, and please, if you have anything to add. I am not a big fan of any type of estate planning document from mailbox, etc., Nolo,
Staples.
Legal Zoom. I am not a fan. I have had clients where they get a cheaper option like that, where it's maybe a couple $100, and then after, when there's an issue with it, it costs several $1,000s to straighten it out. And that's where one of the things that attorneys like me do. So is it legit? Probably. Does it going to get the job done? I don't know. It's to go to an estate planning attorney is not that expensive. You may spend a couple $1,000s, but it'll be still cheaper than trying to fix the problem if the problem arises.
I would agree with what Anita says. And if you are looking for self-help legal resources, I am going to give a shout out to each county's public law library. San Mateo County Law Library has a number of clinics and workshops that will teach you how to use the legal resources there to educate yourself about the topic. But I cannot say, you really need to speak with an estate planning attorney because the problems that are created are huge. But if you do want to learn about legal issues, I would suggest going to the law library. They're open to the public. They have workshops about different topics, and you can educate yourself so that when you do meet with your attorney, you're better prepared.
Mm-hmm.
Okay. And the questions keep coming in, and we've got about 5 minutes. So my question to you, Althea and Anita, can you stay on a little bit longer to answer some more questions if anybody wants to hang as we go through some of these, and eventually I'll cut it off. That's okay.
I can stay.
I can hang out.
Okay. Let's see. Our parents don't have a will, or they don't have a will, nor a trust, nor a power of attorney. Should they start with a will? And about how much do they cost?
So I mean, a will is better than nothing, but you generally want at least the basic 4 documents because they work with each other. They're complementary to each other. You want the will, you want the trust, you want a medical power of attorney, and then you want the financial power of attorney. You can also have a post, and you can get much more complicated, but those are just the standard documents. Full disclosure, I don't do estate planning. I know Althea does. I will give you kind of a general range from attorneys that I work with that do estate planning. Althea would probably be a better person to give you a range. For a simple estate plan that includes all 4 documents, you're probably looking somewhere between $2,000 to $3,000 would be my understanding. But when I say simple, and I've talked to clients who are like, oh yeah, we had a simple will and trust done. And I review that will and trust, and I'm like, no, this was not a simple one. And they're like, oh, that's what the attorney said too. So Althea, what is the ranges that you see?
And I haven't really seen anything below $2,500, but that includes everything. And that includes someone looking at your situation, finding the solution that's best for you. And I wanted to clarify that people don't start out with the will and get a trust later. In California, there are many reasons why it's better to have a trust, and it's really, they have to look at your individual situation. But I have seen $2,500 for everything to $5,000 to $7,000. If you have your own business, that makes it more complicated. If there are blended families where everybody wants their kids to get things, that, the more things to make it more decisions, it gets more complicated, and then it takes more time, and so that costs more money. But many times, you can speak with an attorney and just find out, ask them, what would it cost for this? And they can give you an idea.
And an estate plan is very personalized. I don't want anyone to think that, oh, you go in and they press a button and they create all these documents. It is very personalized. The attorney is going to talk to you about what your goals are, what you want it to accomplish, who you want it to go with. They're going to talk to you a lot of times about how your kids get along. And they're going to give you some great advice, but it's not just a one size fits all. It is very personalized to your situation. And what they're trying to do is make sure that what you want is effectuated through that paperwork.
There was a question in here for Anita, and then we realized Althea does the estate planning, but it sounds like Athena, you just mentioned you can help clients with a blended family determine what's going to work best for them.
Yeah, and I know, Anita, you can answer this too, but yeah, I saw in one of the questions briefly when I was looking at them, a very complicated scenario about who wants their kids and how you want to buy property with multiple owners. So that's something that you should really set up a consultation with an estate planning attorney, and then they can look at your big picture to find out what your goals are, and they can give you the options so that you can make an informed decision. So there's no one answer for that kind of scenario because everyone's family is different. And I know everybody wants to save money, so maybe buy the generic, toilet paper instead of the Charmin, but this is not where you should save money. You should make sure that you have money to invest in this, to make sure things don't get screwed up after you pass away, because I know Anita deals with the ramifications of that all the time.
And for the complicated one, I saw the exact same question. I was scrolled through very briefly about this complicated situation, adding kids on title. And, that sounds like a great idea. As a litigator, I can tell you, I've seen this go awry so many ways, where mom's house, all of a sudden, she puts her kids on title 10, 15 years down the road. Maybe one of the kids on title is an adult, maybe they're in their 40s, they drive intoxicated. Their business goes under and they have a judgment creditor worth $500,000 going after them. They go through a divorce. What happens to it? Well, because your child is on title, there is some liability that mom's house will now be sold, and that child's portion gets either divided with the divorce court or sold to sell a judgment credit for a judgment creditor, and that judgment creditor can file a lien. It gets really messy. So you always want to talk to an estate planner before you do something like that. Save on the toilet paper, save on the paper towel. This is not an area where you want a DIY solution, because the ramifications can be very severe, and it's hard to get the court to come in and rescue you, for lack of a better word, because the court says, you guys figured this out and there were reasons that you did, and there were benefits that you did this. So we might not be able to unwind it.
Mm-hmm. So how is someone declared incapacitated?
So if it is declaring incapacitated, and we're talking about maybe a trustee is declared incapacitated, we're going to look at that document and say, is this person incapacitated? If you're talking about a power of attorney, when that document comes into effect, we're going to look at the document. As a general matter, it's generally decided in most documents, not all because they're personalized, that you need to have at least one doctor sign off. Sometimes it's two doctors. If you don't have any estate plan and you need a conservatorship, it's a doctor. It's a specific geriatric doctor who's going to make that determination. They're going to take you, the elderly person, through a series of tests.
And unfortunately, my grandma went through that. So Yeah, and it's a big deal to have someone, because once they do it, there's no coming back from it. You can't then declare them all of a sudden, I think, okay to make decisions anymore.
Not if it's from dementia. If it's something like they had a heart attack or a stroke and they regain their capacity, that's different. But if it's through dementia that has a normal downward trend, it doesn't go upward. And it becomes very suspicious if all of a sudden you're telling everybody, oh, mom's incapacitated. And then you bring her, then all of a sudden, she ends up with a new will or a trust or a new estate plan. It's very suspicious, and that is elder abuse. The intention could be great. How it was done was an incorrect process.
If you don't own real estate, do you still need a trust? Should you still have a trust?
My answer is always yes. You don't know what your assets are going to be when you pass away. Althea, since you do estate planning?
Agree with Anita too. You should get that in place, and the cost is not that much to really give you the protection that you need. And there's a number of things that you can do. A lot of estate planning attorneys will work with people who are, I guess, on your way of building your career. Maybe you don't have assets now, but they will work with you, and usually they'll contact you from time to time to let you know changes in the law, or some estate planning attorneys have workshops or educational programs. So it's part of kind of you understanding you've spent all your time and effort gathering savings accounts, property. At least make sure that these go to the people who you want them to go to, so that your property is protected. And if the cost is an issue, there are, for every attorney has a different price, but it's something you should look into and investigate and do.
There's a question in here about how old should you be when you start a trust? And the one thing I've learned from all of you is it's never too early to get a trust in place and to start putting those things on paper.
Absolutely.
I'll ask just a couple more, and some of these are kind of going to be, I'm going to tie them a couple of these together. When someone passes along, two parts in here, kind of what's the process that goes through to pass those things along through the trust, and kind of how with the process, about how long does that process take?
The process will determine if it's a will or a trust. But the greater picture, the big picture, is the same in either one. And basically it's going to be, you are marshaling all the assets, or the person who's in power to do this, marshal all the assets, pay the bills, pay the expenses for administration. And then after all of that is done, the tax returns have been filed, everything's been done, it is to distribute it according to the document or to the heirs at law. A probate, when you probate a will or somebody dies without a will and you have to go through the formal probate process, it's going to take longer than with the trust. And that's because there are certain times that you have to check in with the court. There are certain actions that you can take, but only with court permission. And right now our courts are impacted. They were closed for several months and months because of COVID. In Santa Clara County, they were closed for almost 6 months. You could only get into court if you had a criminal matter, or if it was literally life and death, an emergency conservatorship, or decisions like, should this person be taken off life support? It literally had to be life and death. Because of this, our courts were already impacted. They were already having budget cutbacks. This did not help. There were more budget cutbacks to the court because of COVID and during COVID, and they're still there. And because the courts were not hearing matters for several months, all of those cases were backlogged while new cases were coming in. So currently in Santa Clara County, San Mateo County is not quite as bad. Alameda County, when you file a petition for probate, it's going to be, they're trying to get it 30 to 60 days from the time you file until you get until you're actually in front of a judge. But everything else, it can be a couple of months from the time you file until you can get a hearing for the judge, unless it's an emergency matter. An emergency matter is this house has to sell tomorrow. An emergency matter is the trustee is going to take all the money and has a plane ticket to, I don't know, to Brazil. So if it's a trust, you're probably looking at 6 months to a year. If it is a probate estate, you're looking at about 18 months. The more complicated the trust is, or more complicated the estate is, whether it's a trust or a probate estate, it's going to be a longer time frame. If there is infighting with the beneficiaries, that's going to draw it out longer. If they're within that infighting, if there are motions being done, discovery motions, motions to dismiss, that's going to drag it out longer. If the court all of a sudden has a bunch of objections at the last minute, it's going to make the process longer. If the trustee has to file something because some of the assets were not put into the trust, that's going to delay it. So there's a lot of things that can delay it. 6 months to a year is probably the quickest in a trust. A year is probably the quickest in a probate estate.
Thank you. Gosh, there's so many questions in here. You guys can see the questions. Are there anything that you see in this Q&A box that you want to answer? It's hard to pick them.
I think it seems like a lot of people are asking specifics about their own situation.
Yeah.
And so what I'm going to suggest is that the San Mateo County Law Library on the third Tuesday of every month from, I think it's like 5 to 8, has free estate planning and family law attorney appointments. So you can get an appointment for 20 minutes with an experienced estate planning attorney at no cost. And these simple questions are, this is a great way to get that answered, because 20 minutes, they can talk to you, tell you what you need to do. And at least you're talking to someone who is licensed and practices, we'll focus on the estate planning, practices in that area in estate planning. And I can just give you can look it up on the San Mateo County Law Library website. You just need to call them and set up an appointment, and it's part of their community outreach program. And that might be a way, because I see a lot of specifics in here that I don't know if.
Yeah, in Santa Clara County, we have Sala, who does estate planning. Like once a year, they'll do an estate planning seminar and help seniors or elderly individuals with that. And generally it's either free or on a sliding scale. Additionally, in Santa Clara County, through the Santa Clara County Law Foundation, they have lawyers in the library. And it's up to volunteer attorneys, but they know at least the basics of estate plan. In fact, there's generally an estate planner there or somebody with that type of expertise, and you can take advantage of that as well.
And I will say the San Mateo County Law Library Community Law Night is open to anyone. You don't have to be in San Mateo County. And the estate planning attorneys usually do things in San Francisco, San Mateo, and Santa Clara.
Yeah, I really like the presentations that the San Mateo, San Mateo Bar Association does with that. In the San Mateo Law Library, they have a little bit better resources than we do in Santa Clara County, but once again, it's open to the public. You don't have to be a resident of San Mateo County. And most attorneys that practice in one county practice also in the surrounding counties.
Sounds like there's a lot of resources out there between the different county law libraries, and it's just a matter of going online and again, scheduling that appointment to get some of these questions answered. Anita, and yes, Anita.
I was going to say, I would like one of those answered, because it's
not
probably specific for them. And it's actually a question for Althea.
Sure.
There is from Gabby, is there any state or government assistance available for elderly care homes? I know that we have this, it is a very elderly care homes and assistance for that. My personal thing is we fail our elders in this, and there's not enough resources. So Althea, if you know of any resources, because this is kind of in your ballpark, in your realm, if you know of any resources, I would love if you could answer this.
So long-term care is not covered by Medicare. So that means if you have a situation or a medical condition, such as a loved one develop dementia and they cannot live safely in the home, or you can't take care of them, you have to pay for that. And so I know there are estate planning options. So I know that certain attorneys specialize in basically like protecting assets so that you can qualify for Medi-Cal. But if you look at that and what you get, if you get a Medi-Cal bed in a facility, it's probably not where you really want to be. That is why the continuing care retirement community is an option, because that is one way, if you put aside the money for that you can care for yourself and make sure you have the care, especially if you don't have family who can take care of you. If you do have family and you think they won't take care of you, that is one option. The other is getting long-term care insurance, but that is expensive, and finding a good plan is sometimes difficult. But some employees of government entities will make this available to their employees who pay for it. And then through that, sometimes family members of employees can qualify for that too. But that's really the only thing. And it's really, we talk about as a real estate broker, I hear all this stuff, oh, there's going to be all these older adults wanting to sell and move. But what we're not talking about is the significant crisis we're going to have and who is going to take care of people. Because we're in a situation now where the day-to-day staff who takes care of people get paid less than what someone working at Starbucks gets. And you are doing a heck of a lot more things that people don't want to do. And the level of care, people do that because most of them either need the money, or they love what they do, or they need the money. And this is, they want to help people. I don't know what we're going to do. And this is going to lead to many problems down the line. And the only thing I can tell you is start saving your money and putting it aside, looking into long-term care plans, and then using estate planning techniques to preserve assets so that they're available. I don't have a good answer.
I think that's the best answer. I agree with you. We are in a crisis, and we are underserving our elders, our elderly or senior population. And you're right, it is a crisis, and it does not get enough. We don't talk about it enough, and we don't bring awareness to that. But ask anybody who's been a caregiver. It's stressful. There's no gratitude for it. It is the hardest job you'll do, and there's no I get off at 5.
And some of them have, I've learned, 2 jobs. So
Yeah.
there are, and I think unfortunately it's been highlighted by COVID, where we're seeing care facilities where there's the caregivers that are working at 2 different facilities
and
to make ends meet.
They're working full time. So I know that's with my experience, that people will work in the morning in one place and then do swing shift at a second. And some ambitious people will try and get private duty to work at nights. I had a client who needed 24-hour care because post-surgery, and the person she hired at night was just sleeping because they probably had 2 other jobs. When you look at someone getting paid $16 an hour to do very messy work, it's just not sustainable. In our society, we seem to value professional athletes and what they provide far more than teachers, than people who take care of our young children, than people who take care of our elderly. And it says what we value in our society. And we really need to look at different models and change, but that's another presentation.
And that doesn't even include the family members who have to leave their job because mom needs care and there's no assistance for mom. So no, I agree with you 100%.
How these contagious diseases spread, because before COVID, it was norovirus. So someone would work as a CNA in one community and then go to their afternoon job in another community, and they were exposed to norovirus, and then they'd spread it to the other place. So when they do the tracing, they can see who worked where. But pretty much many of the CNAs I know are working 2 jobs.
Yeah.
Well, this is a ton of great information. For those of you that stuck around, thank you. And thank you to Anita and Althea for sticking around and answering some more